All right, Paul Sponcia, CEO of the IT company, working in the comfort of my home under COVID-19 pandemic stay-at-home orders, as all of us. And I'm here with my friend and my attorney, from a business perspective, John Wood. And I'm going to let you tell everybody who you are and who the firm is and kind of what your specialty is, and et cetera.
Okay. Yeah, my name's John Wood. I'm with Egerton McAfee here in Knoxville, Tennessee, and we are a general purpose law firm that represents businesses like Paul's in all types of matters, from litigation to transactional matters. My background is specifically in software. I have an undergrad and master's in computer science. I worked for an extended period of time in the software industry before I went to law school. And so my practice has focused around assisting technology companies, software companies, and then with licensing issues, software, technology, do a lot of trademark work, copyright work, those types of things. And also general business work as well.
You said something that's important, is you can't just not perform because there's an event and you have force majeure. It's not like, oh, event, force majeure.
Right.
It's
right.
like you still, what you said was like there was some requirement to attempt to perform. It wasn't like you could just be like, they shut us down, we're done, we're not going to try anything, whatsoever. So it sounds like there's an element of that where the courts might look at it and say, well, did you at least try to do, the best you could to offer the services, and versus just being like, I think about restaurants, a lot of, my wife owns 2 restaurants, and a lot of restaurants have worked very hard to continue to operate and maintain and, et cetera, where they've made an effort versus just being like, oh, well, sorry, we're just going to shut it down and call it quits.
Right. And as you know, for a lot of businesses, you can work from home. Maybe it's not convenient, but with our technology. And so it really wouldn't be acceptable to just say, oh, we work in the office, we don't like working from home, so we're not going to provide our people with computers. We're not going to set up a VPN. We're not going to, we're not going to set up any kind of infrastructure to allow them to work from home, so we just can't perform any of our contracts during this time.
Right.
If you have the ability to do it another way, you need to do that.
Right.
So, you can't just use it. You can't use it as an excuse. That's not going to work, because the other side is going to try and say, kind of like Peep Brothers did, say, well, they could have made it on time, they just didn't try. Right. They were using an excuse, and their factory was closed. They couldn't do anything. So they had a pretty good excuse.
Yeah. Well, I pulled mine up since you mentioned it, and it obviously disclaims all this stuff, but I can't be like, oh, well, pandemic, we're just, it's not going to provide services. Don't worry about it. We'll get back to it when the restrictions are lifted. No, we have done everything possible, because I never actually want to deal with this clause. I don't ever want to. Obviously, if push came to shove, you'd want to use it as a risk mitigation tool, but I don't want to get there. I want to do everything I can to keep a viable operating business, support my clients, serve my clients, et cetera. So I think that's an important note for sure.
Yeah, I think so. And I think it builds goodwill in the future. If you supported your clients during this, you're going to support your clients during anything.
Yeah.
It's what they're going to think. And if you just shut down, they're trying to operate their business. They need your help.
Yeah.
Right?
Yep.
And
right.
So I think it does build a lot of goodwill.
Well, we're getting to the end of our time. Are there any other things you thought of, John, that you wanted to get out there for people to be aware of?
I had one other case that I thought was really interesting, and it's in this landlord-tenant space. So after 9/11, there was that, which was obviously a force majeure type event. It turned out Cantor Fitzgerald, which was in the World Trade Center, had prepaid their rent. They had a front-loaded lease in which they paid a bunch at the front for certain concessions from the landlord. Okay. And so, to boil down the case, basically they wanted to get the money back because they said, we paid a bunch up front and you're not able to provide the property because the property is gone, so we can't go there, so you need to give us this money back. And the lease had a provision that the landlord, the Port Authority, wouldn't be liable for any failure, delay, or interruption in performing its obligations due to causes beyond its control, force majeure event, and causes or conditions beyond the control of the Port Authority means acts of God, war, acts of third parties for which the Port Authority is not responsible, which would be the attacks. And there, because of that clause, the court found that the defendants are sophisticated commercial tenants. There's no reason to excuse them from operation of the force majeure clause, which they freely negotiated. They bargained away their right to hold the lesser liable for non-performance. And so in that case, the Port Authority didn't have to give the money back.
Wow.
They said because of the force majeure clause, which was in favor of the landlord, that said, there's this event, we don't have to perform anymore. Mm-hmm. They didn't have to give them the money back.
Yeah.
So
it shows both sides of it.
Yeah, it really does. So you really have to be careful